Hello and welcome to the big picture. The Parliament has passed a vital law, the Insolvency and Bankruptcy Code 2016, which is aimed at making it easier to do business in India by providing for time-bound resolution of insolvency processes, faster turnaround of businesses, and to create a database of serial defaulters. This code repeals some outdated laws and amends various laws related to banking and industries. However, there are many challenges, it is said. One of the challenges after the passing of the law is to ensure effective functioning of insolvency professional agencies to discharge functions which are presently being discharged by the courts. This law, which was passed after a JPC looked into it, has found almost unanimous approval from all political parties. However, already concerns have been expressed about how effectively it would be implemented. Most importantly, how will this new code help in the lakhs of crores of rupees which have now become non-performing assets? How will this help the poor farmers who, unable to repay the loans, are resorting to suicides by the thousands? We will discuss these and other issues with an eminent panel of guests. I have with me Ajay, former Secretary, Ministry of Commerce and Industry; Harish, Salve, Senior Advocate in the Supreme Court; Prof.Arun, Kumar, an expert on black money from Center for Economic Studies and Planning, JNU; Sanjeev, Gupta, Chairman, Banking and Financial Services, PhD, Chamber of Commerce; and Mukesh Mohan Gupta, former Director, Dena Bank. Welcome to all of you. Mr. Salve, how is this law different from the existing laws, and what do you see as benefits to the larger public?
See, the problem which we have always faced in India is, unlike for individuals, there is no corporate bankruptcy law. We had what was called the BIFR law, the Sikh Industries Act. And that actually became a haven for Sikh companies to go and hide behind the statutory curtain and have your creditors lose most of their money. Insolvency law was a corporate insolvency law was the need of the hour, where a company could go into corporate insolvency and either get restructured or get wound up expeditiously.
Right.
So that the kind of drift which we see under the Sikh Industries Act does not take place. Secondly, the Sikh Industries Act is not across the board. It applies only to industries and some, whereas the commercial insolvency law applies across the board. So this was a big gap in Indian commercial law rubric, which I think has been filled up by this legislation.
Sir, it is said that one of the main features of this law is that, unlike in the past where the creditors were given importance, were given the primary importance when it came to when it came to settling accounts, it is now not the creditors but the debtors or people who have to be first paid up, which will have the importance. How do you look at that? If I take the case of, say, Kingfisher Airlines, sorry, let me finish the question. Will the employees who are there, who are now waiting for their salaries which have not been paid for several months, will they be first paid their salaries before the banks can take their monies?
That's a very important question you asked, and I think this is a bit of a misconception. See, what is happening is, even under the amended Companies Act, we amended our Companies Act almost 30 years plus ago, in which we gave employees rights pari passu with secured creditors. The old conventional understanding of corporate insolvency, that a secured creditor stands outside the winding up, has been substantially impaired by this socially sensitive legislation, which gave employees a right pari passu with banks. Now, that has nothing to do with the bankruptcy law. That's already there in the Companies Act. What happens is, Sikh Industries, Kingfisher did not have the Sikh Industries Act applicable to it because it applies to manufacturing industry. It doesn't apply to airlines. So what has happened in Kingfisher is it has just floundered. There is no bankruptcy law under which it could have been effectively and quickly brought into a winding up. It has Kingfisher has therefore been taken through the normal route of the Companies Winding Up Act, which takes a lot of time. Then you have winding up petitions and so on and so forth. Whereas Kingfisher would have been now compelled to declare bankruptcy a long time ago. Then it would have been under administration, whether further loans had to be given, whether further loans would not be given. All that would have been regulated, and the mess which we see today would never have happened.
Okay, that's interesting, Mr. Ajay Dua. You think, it's very interesting how all political parties came together. Nobody really objected to this law. They all, despite the fact that JPC was formed, the JPC found unanimity there also. You think that all these NPAs have been bothering the political class, and is that the reason why this code came through so quickly?
I think the government handled this entire issue of enacting a new law extremely well. One, as soon as the finance minister in his 2014 budget speech talked about the need for having such an enactment, he set up an expert committee under a former law secretary who did his work very assiduously. And once his report was presented to the parliament in the Lok Sabha, that was immediately referred to a JPC. And the JPC, all-party JPC, which had people who had commercial experience, members of the government, people who had worked as ministers earlier or held positions of authority, and they came to a working solution, and there was unanimity amongst all the members in the JPC, presented in Lok Sabha, passed that very day, remitted to the Rajya Sabha, passed in about 45 minutes of discussion. So I think this was a good way of building consensus, and probably there are lessons in it for other legislations which the government might want to bring in.
No, but Mr. Prof.Arun Kumar, when it comes securing creditors, taking precedence over taxes to the government, what Salve was now saying that, if that had been in place, we wouldn't have had the mess which we are seeing as far as Kingfisher is concerned. Right. Kingfisher is a celebrated case, but I'm sure there are hundreds of such cases.
Yes. My take would be that let's look at the economic reason why this happens. The economic reason is that in capitalism, the borrowers and the savers are different people. So the households are the savers and the businesses are the ones who borrow because they have certain amount of equity, and on top of that they do borrowing, what's called the gearing ratio. The higher the gearing ratio is, the more the risk of the investment is. Okay. Now, those who are the intermediaries are the banks and the financial institutions. Now, they are to do due diligence. Now, if they do not do due diligence, then there's no way you can secure your loan. The problem in India is twofold. One is that you can be a part of a business cycle, that there may be a downturn and therefore your profitability goes down. The other could be business fraud. Like the banking division is under pressure from the political parties to give out loans, etc. And once those kind of loans are there, then you have a problem. Second problem is that for a company to borrow, you require good credit rating.
Right.
Now, good credit rating means that you have to show a good balance sheet. So what is done is very often the balance sheets are doctored. For instance, in the case of Raju Satyam, 6,000 crores of rupees of fixed deposits are missed out by the internationally well-known chartered accountants. So how could you do it? Secondly, what happens is that businesses, even when they begin to make losses, what they do is they delay showing those losses on the balance sheet by doing creative accounting. And therefore, it's difficult to find out whether a company is going under or is not going under. Thirdly, what happens is that in India, there's a consortium of banks which are lending out. Therefore, you may borrow from one bank and repay through another bank and through a third bank. That's what happened in Kingfisher's case. There were a large number of banks that even the name of the Kingfisher was capitalized and the borrowing was taken on that account, etc. So due diligence was not being done. Also, the banks were not really finding out where the default is taking place. Now, under the new provision, there's a utility clause where a large number of this data bank will be created. There'll be professionals, etc. But if the companies are doing creative accounting, then it will be very difficult to find out. So you will find out only if a company is really gone bankrupt rather than earlier.
Mr. Gupta, you have been a banker. You've been in the hot seat So how does this new code going to help the bankers from the bankers' point of view?
No, we are very positive. From the banking point of view, I'll say, so bankers are very positive about this thing because the NPA problem, you rightly told that NPA problem has messed, in fact, the entire economy. What was happening, in fact, and we should thank the Governor, Reserve Bank of India, in fact, because he brought this AQR, and otherwise it would have been going on. There are a lot of schemes like CDR, SDR, 520. So because of that, I suppose that NPA issue was, we were just postponing it, in fact, declaring the NPA. What happened in the past 2 quarters? More than 40,000 crore rupees have been provided. All banks have been into losses. So, and it is very difficult for the bankers, though there are certain other acts like Securitization Act is there.
Right.
So, the powers have been given to the banks. In fact, earlier the situation was that, bankers have to go to the court, and then it was taking a lot of time, years and years, in fact, to recover the money. But then Securitization Act came into picture. That has helped us in some way. I'll not say largely, because there are again, various courts, stays, and all those things are there. But as far as the banking community is concerned, we are now quite hopeful that there is some timeline is there. So within 180 days or maximum by 270 days, something will come out.
And also, it is said that earlier you were waiting for the companies to go bankrupt before you could act. Now you can act even in between. You can wait and you can watch more closely what the companies are doing, what the industries are doing, whether they are paying their employees, their defaults are getting higher, so that at the end of the day, you are able to control or watch the companies more closely. Is that something which
no, sure, because earlier what was there was 2 types of lenders: secured lenders and unsecured lenders.
Right.
Secured lenders were definitely having some edge over the unsecured lenders. They were able to recover the funds. Now it is under this Bankruptcy Act, there is no classification of secured or unsecured. Both are at equally even. So now they have classified as financial creditors and the operational creditors. Even somebody has supplied the goods and the company is not able to pay to that creditors, he can also file an application for the bankruptcy. So that will definitely help. So what will happen ultimately, the credit availability will be much better what it was earlier, because now everybody will be afraid of this thing. Otherwise, if he doesn't pay on time, so he will be going for the winding up, in fact, within a period of 180 days. So credit availability will definitely be...
will improve?
Yeah, definitely will improve.
Will improve, okay. Mr. Salve, coming to the, there is some criticism already saying that this law is more heavily tilted towards the creditors. It is not tilted towards the debtors. This committee of creditors will decide, will become all powerful. They will decide how to rework this, rework the loan, or winding up. The debtors will not have any say in this matter. Do you agree with that criticism?
Completely. See, let me tell you, as one of those panelists said a moment ago, SARFAESI had limited results. When the SARFAESI, the Securitization Act, was brought, we thought this would enthuse more than immediate legal remedy. This would enthuse a sense of discipline amongst borrowers, who would know that it is now by a stroke of a pen that a secured creditor can take over your assets and realize his debt. But unfortunately, the mindset, I'm sorry to say, of our courts doesn't change. So even the SARFAESI actions are all bogged down in litigation. The time has come, as in the rest of the world, if India needs to take its place in the sun and be for it.
Mr. Salve, I think there is some problem with the audio. We'll get back to you. Let me go to Sanjeev Gupta. Mr. Sanjeev Gupta, you belong to the PhD Chamber of Commerce.
I can hear you.
Mr. Gupta, can you hear me?
Hello?
Hello.
I can hear you, sir. I'm not sure if you can hear me.
Mr. Salve?
Yeah, I can hear you, sir. I'm not sure if you can hear me.
What about, is Mr. Gupta there?
Yeah.
Okay. There's some problem with the audio with both of them. We'll get back to them. Mr. Ajay Dua. Mr. Ajay Dua, now the question is, there is also another, one is what I asked
yes,
Mr. Salve, that, who will get more this thing. Second issue is, another criticism or concern being expressed is, this is some kind of a one-size-fit-all law. It includes both personal insolvency and corporate industrial insolvency in the same way, it treats both in the same way. Is there a problem there?
I don't think so, because under this law, the adjudication authorities are two. NCLT, National Company Law Tribunal, will be dealing with corporate default plus the defaults by limited partnership companies, LLPs. And the DRTs, and we have 33
Debt
of
recovery
yes,
tribunals.
and we already have 33 of them. They may not be very well manned, etc. They are to deal with individual defaults and those who have unlimited liabilities. So there is a distinction made there clearly already. The question here is a little more complex, I think. Even under the DRTs came to be set up under the 1993 legislation, and under SURFACE, what was being talked about when the audio got interrupted, there was the provision for securitization debts, etc., to be recovered. Under both the laws, also there was a limit prescribed of 180 days within which relief would be provided to whosoever had approached the DRTs or invoked the Securitization Act. In practice, we've seen it's been taking very much longer. That is why, if you will recall, the finance minister, when he was introducing the bill, had talked about, referred to the World Bank report, where it said it's taking in India 4.6 years to recover 25 cents out of a dollar. And it had put India down on a 136th position. Now, the moot point, and that I think is the one which has been coming as by way of a criticism, saying if even the earlier laws had this time limit, how will this law, which talks about 180 days plus 90 days one-time extension, etc., will it be very much different? Because we have the same set of DRTs. We are creating another tribunal, NCRT, under the company law. Plus, we are creating here a huge infrastructure of professionals which does not exist in the country.
Insolvency professionals.
Insolvency professionals, IPAs, and then a board. All of them have also to be manned by people chosen by the government.
And that is that's where there is a concern also.
Yes, concern is that are we putting too much on the state meaning the government, compared to what it was in the past, and then expecting that the government this time will be more efficient, more professional, what it was under the two previous laws.
Okay, that's very interesting. That's a, sir, Prof.Arun Kumar. My question, I think you need to address this situation. Thousands and thousands of farmers have been committing suicides. These debt recovery tribunals have existed, as Mr. Dua has pointed out. Now, and he says that the personal insolvency and the corporate or industrial insolvency are two different. They'll be handled differently. Do you think that DRTs will now be, at least will these farmers facing this kind of situation, instead of committing suicide, will they be able to go and approach these kind of places, declare insolvency, and then get out of the debt traps?
My fear is that while in principle that would be there, but in practice that would not happen. And the reason is, farmers have a different business model than the business model of the businesses for which this bill is made. The model.
So this is not really aimed at those farmers.
That's right. Yeah, it's not really aimed at that. And the business model.
People who have taken a loan of 25,000, 50,000, a lakh, and then they're unable to repay, and then they die. They commit suicide.
Yeah, they're not going to be able to really approach all this and manage all this. And we must understand, you see, one of the reasons why our businesses do what they do is there's an umbrella pattern of holding. So you have, like in Tata Sons will hold 2% of this, Tomco will hold this much, Tata Steel will hold this much, and so on. And therefore, there's a confusion that is created deliberately by businesses. That's what happened in the case of the UBS. That's what happened in the case of our Kingfisher and his, alcohol company, and so on and so forth. The second is, you see, because of the black economy, there's a tendency for overcapitalization. So if you have an industry of 100 crores, you'll declare it to be 130 crores, siphon out 30 crores. And when you have overcapitalization, then what happens is that the capacity to repay is less, the shareholders lose out, etc., etc. None of this will be addressed by these kind of laws. So my fear is that it's like in the USA. You have had bankruptcy laws, you've had insolvency laws, all that. And yet the biggest financial crisis started in America in 2007. because there was subprime crisis.
Right.
Because the banks are told, the credit agencies are told that you have to push loans. You know, as long as you're pushing loans on entities which are really not credit worthy, then you will have this problem.
We have the, and we right now have that problem.
Have that problem.
We have this problem of 6 lakh odd crores.
And
NPAs.
Yes, and also, you know, how credit is being pushed onto people who are not really credit worthy, who may not be able to repay. So credit cards are being pushed by banks and by other financial entities, and then the credit is rolled over, and then you have these strong men who are recovering the loans, etc., etc. Because you
all
can't
those,
do it.
all those will not come under this.
All that will not be covered by all this.
Okay. Let me go to Mr. Sanjeev. Mr. Sanjeev Gupta. Now, from sorry, you know, we have been having some audio problems with you. There are audio video problems. But Mr. Gupta, you know, looking at it from the industry's point of view, you think that this law will be helpful to the industries? Will industries be able to, you know, get out of these problems much more easily now? How does the industry look at it?
Very important question, sir, from India's perspective and industry's perspective. Let me start from India's perspective, because this law has now been passed before 30th May, which means that with the enactment of that and with the resolution of this problem of, you know, the insolvency coming in before 30th May, our World Bank rating, which will take all the resolutions and all the reforms to 30th May, is bound to increase, and it's going to be a great contribution into that. So which means the global rating of India will actually go up. So that's one good news. Second, for the industry, why it helps and how it helps is a very important thing that, you know, what happens is that once the resolution is available in a very, very important, in a time-bound manner, the entire quality of credit improves. And furthermore, the industry is also assured of a quality credit. At the other hand, there is a Damocles sword which hangs that, you know, if you don't do very well, you can actually be,
Declared
pushed into this insolvency. And second most important thing is, am I audible?
Yes, please continue, sir.
Yeah. So, most important thing in this series of things is, you know what, when you actually look at it, the banker, the lenders, and you gave a very classical example of a company called Kingfisher. Imagine for a moment that the employees, actually, you know, one important aspect of this resolution, this code we call it today, is actually that the employees get assistance even over the government's dues, which means that the employees are able to, you know, get their dues up to 24 months' salary. The company has a great chance of actually surviving. And there is a possibility that, you know, if 75% or more of these creditors agree, within the next 3 months, they are able to revive the whole company back. So which means there is a great chance of revival also.
Okay.
From industry's perspective, another important aspect is that there is no stigma now attached to the whole thing.
That's a very interesting thing. Point which you have made, Mr. Gupta, to Mukesh Gupta. There are two Guptas here.
Yeah.
So, you know, does this code also make bankers more accountable? Because, you know, when these NPAs are happening, how many bankers have been hauled up for giving bad loans?
Sir, bankers are already having a lot of fears of the accountability. So that fear sometimes...
They may have fears, but we have not seen action being taken against them.
Action has been taken, but as Mr. Salve has rightly told, in fact, there are a lot of litigation issues, in fact. And sometimes we bankers are stuck up in the lot of litigations also at the DRT level, at High Court level, at Supreme Court level. But I will say that this will definitely be a good act, but it will depend on the implementation of this act. So implementation is very important, as the London panelists were discussing about the, you know, ease of doing business, rating, in fact, from 136. Now it is told that instead of 4.6 years, it will reduce to 1 year. But ultimately, how the implementation will be done, exactly. I suppose, and I would like to add one more thing.
Paper right now.
I would like to add one more thing. I suppose the timing of passing of this act is not very encouraging to me, in fact. Yeah. The situation of the economy, as is told very rightly, is not very good, in fact. So it is true that the timeline has given, in fact, 180 days, and then in an exceptional case, additional 90 days has been given. Who will be able to acquire those assets or those businesses? That will be a very big question.
That is the point.
Because, see, what is happening, sir, in today's time, I suppose it has become very difficult even to sell off a flat of say 2,000 square feet.
No, we have seen this happening with the Kingfisher's assets. People are not there to buy the
Yes, sir.
assets.
So the resolution will depend on the situation that somebody will come and acquire that property, and then valuation will also be going to be a big issue. So those implementation issue will be there. I little doubt, in fact, on the timing of this act, how it will be able to resolve the issue with the help of consultant and the bankers and that NCLT or DRT.
And also the important thing of creating this huge infrastructure of insolvency professionals, from where will they get them? All these, there are still a lot of questions which are being raised.
And then one more thing
about
will
it.
be there, sir,
Yes.
because what will happen, in fact, if somebody is declared insolvent, then at least in the CIBIL, because every bank, what they do, in fact, they go, as soon as anybody comes for any borrowing proposal, debt proposal, we go to the CIBIL. And the name will not be stuck up for a period of about 8 to 10 years, in fact, if somebody is declared insolvent. So he will not be able to get any fresh funding from any financial institution or lender, in fact, in future.
No, but Mr. Gupta, Mr. Sanjeev Gupta was pointing out that, following this act, that stigma against insolvency is going to be reduced. Do you think so?
I think that is probably right for one reason, that as soon till, you see, let's distinguish between insolvency and bankruptcy.
Right.
That is why the act or the code
It's called insolvency
is
and
both.
bankruptcy code.
Otherwise, we tend to interchange the words, and that is where the stigma question arrives. Insolvency can occur on account of various reasons. Some of those could be genuine.
Right.
Some could be not
Deliberate.
necessarily, and we reach the stage of bankruptcy. The bankruptcy can, in theory, now be declared much more quickly than it was there earlier. It may not be as fast as a Chapter 11 in the US provision, but it can be much quicker. The fact is that the people who have been defaulted, who have been declared bankrupt, now there is an information system which is being created, the utility which is to be set up, information utility, that will help other creditors in future not to deal with those persons.
Okay. So there's going to be a list of defaulters.
I just want to make one other point.
Very quickly, sir.
I think under this code, we are expecting far too much of the state. We state, again I say...
Not expecting, it is inbuilt in this law.
No, exactly. So could it have been, I just want to leave this thought, could we have left much more to the market forces rather than leaving this to the state?
Exactly, that's very quickly, sir.
Very quickly, the judiciary's role will be very important, because implementation will depend on that. And there are a large number of cases stuck up in the judiciary. You see, like for instance, check bouncing was a very welcome Section 138 which was introduced. Earlier, 3 months the cases used to be decided, now it takes years and years. Similarly, 12(6), if you have a registered lease deed, it was supposed to be decided in 3 to 6 months, it takes years and years. So we start off very well with very well-defined things and good bills, but then these cases get stuck up because resolution is very difficult. Secondly, every company is worried about its name, because its creditworthiness is very important for getting further loans. Now, if you are declared even insolvent, I mean, even that would come in the way of your, having a... So therefore, the company will do creative accounting so that they won't show their loans early, and that will delay the process to begin with. So it's inbuilt into the system that, to track when you become insolvent, etc., becomes difficult. Finally, already within the banking system, who's really not repaying, etc., etc. So it's not that information is not available, but it's not acted upon because of political pressures and others.
But, these are the kind of concerns which have been expressed, but we hope that this law, this code will help bankers also to track their debtors and be able to deal with them more easily than they were in the past. Anyway, there are several questions, but as on the whole, it's a welcome act. We'll have to wait and watch how it will be implemented. Thanks to all my guests. Please keep watching. We are completely run out of time. Please keep watching. We'll come back with another issue in the big picture same time too.